Is anyone on?
Good morning. You can come in. You can come aboard. Good morning, Mr. Oriana. Are you able to elevate either Mr. James Bassett or Mr. Steve Walker?
Stephen Walker, your access has been elevated.
Good morning.
Good morning. Good morning, Mr. Walker.
How are you, Mr. Chairman?
I'm doing well, thank you. You're doing well.
Great. Mr. Grant, how are you?
I'm great. How are you?
Good. Congratulations on your confirmation.
Thank you again.
Good. We're glad to have you. Are we ready to start, Mr. Chairman, with the swearing in?
Yeah. Yes, we are.
Mr. Short, how are you? Good to see you.
Good morning.
All righty. Well, let's make
See
the
you
two
also.
of you official once again for Mr. Grant and Mr. Anderson, and welcome to the commission for Mr. Grant. So if you both raise your right hands and repeat after me. I, and state your name.
I, Donovan Anderson,
Having been appointed as a member of
having been appointed as a member of
the ABC Board,
the ABC Board,
do solemnly swear and affirm that
do solemnly swear and affirm that
I, and state your name,
I, Donovan Anderson,
will support and defend the Constitution of the United States
will support and defend the Constitution of the United States
and the laws of the District of Columbia,
and the laws of the District of Columbia,
and I will perform the duties
and I will perform the duties
that may be assigned to me
that may be assigned to me
as a member of this board
as a member of this board
to the best of my ability,
to the best of my ability,
without fear or favor,
without fear or favor,
that I will exercise my best judgment
that I will exercise my best judgment
and consider each matter before me
and consider each matter before me
from the viewpoint of the best interest
from the viewpoint of the best interests
of the District of Columbia
of the District of Columbia
as a whole,
and
I will faithfully discharge these duties.
I will faithfully discharge these duties.
Very good. Congratulations. Welcome back, Mr. Chairman.
Thank you very
Welcome
much.
to the board, Mr. Grant. You will receive a printed copy of the oath that I issued that you'll just need to sign and get back to our team. And then looking forward to your successful tenures on the as a member of the ABC board.
Thank you very much, Mr. Walker. Have a great day.
You have a good one.
Good morning. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2571 et seq of the Open Meetings Act, OMA, I am welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I am chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your name. Mr. James Short.
Mr. James Short, present.
Mr. Silas Grant.
Silas Grant, present.
The board has 3 members in attendance for the conduct of business, and that constitutes a quorum. And I would like to formally welcome you to the board this morning, Mr. Grant. Both of us were confirmed by the DC City Council yesterday for 4-year terms, and I do look forward to working with you for the next 4 years. So again, welcome to the board, sir.
Thank you for the warm welcome.
All right. All right. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 5 cases scheduled for this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. The first case on our calendar this morning, it's case number 23, PRO 00077, Minyas Pizza, license number 125665. Good morning, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Sure. Good morning. John Holohan, your access has been elevated.
Morning.
Not seeing any of the other folks.
All right. Mr. Gabriel Mescal is not online.
No.
This is Mr. Holohan, have you had any conversation with Mr. Mescal, Gabriel Mescal?
Yeah, we're working on a settlement agreement. I've got a couple issues that I'm just trying to work with neighborhood association members with. I do think that we can reach a settlement agreement pretty easily. I hate to see the establishment punished. So I feel like there's not really any problems with it being here. It's just selling pizza and alcohol. So I think we just have some issues with trash pickup, and we should be okay.
I think one of the problems that we have this morning, and we'd had this concern before, the parties have to show up at the roll call and the protest hearing status. And if the party does not show up, I have no choice. I'm sorry, he said that he's here. Is that Ted? Is that all right? Who is Ted? Can you turn your camera on, please?
Okay.
Do you have a camera, sir?
Yes.
Good morning, sir. What is your name? And could you please identify yourself for the record by spelling and stating your name?
Okay. My name is Tedros Haptamariam. I'm the manager of Nias Pizza, and my first name is Tedros, and my last name is Habtemariam. I can type it here also if it's a problem.
You said that you're the manager. What does that mean, sir? Is your name on the license?
No, but the owner is here.
Where's the owner, sir?
I think
Where's the owner?
Do you see him, Yosef? Do you see?
All right.
I think he's right here. He's right here.
All right. Okay, so the individual whose name is Yosef, if you have a camera, can you please turn your camera on? The individual whose name is Yosef, do you have a camera? If you don't have a camera, are you able to speak?
I sent him a unmute request.
Okay, thank you, sir. All right, Mr. Yosef. All right, can you unmute yourself, sir, and please spell and state your name for the record. You need to unmute yourself.
Okay, can you hear me?
Yes, sir. Spell and state your name for the record.
Hi, everyone. My name is Yosef Aradom with YOSEIFF as in Frank. And my last name is Aradom, ARAD as in dog, OM as in Mary.
And what is your relationship to this establishment, sir?
I'm the owner, the first owner of this business.
All right. Thank you, sir. Mr. Holohan, can you identify yourself for the record by spelling and stating your name?
Sean Holohan, SEANHOLIHAN, and I'm the ANC commissioner for 1B02 and the chair of the ABR committee for ANC 1B.
Good morning, sir. Good morning. Let me. All right, this was an application. Before we start, there's some procedural issues, procedural concerns that I need to address. The applicant was dismissed from this case, and it's my understanding that the applicant had filed a motion to be reinstated, and that motion is on our legal agenda today. But before we start this case, I need to make a motion to formally reinstate your application. And so therefore, I make a motion that the applicant's application in case number 23PRO00077, Minyas Pizza, be reinstated. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
I agree.
Mr. Anderson, I agree. The matter passes 3-0. So therefore, sir, we have now reinstated your application to move forward in this case.
Thank you.
So are there any preliminary issues or just matters that you have to bring to the attention, not substantive, just preliminary. I know that earlier, Mr. Holohan, you had stated that it appears that the parties might reach an agreement. You just have some fine details that you need to work on it. That's correct?
Yes, sir. The establishment has sent ANC 1B their settlement agreement. I'm currently working with members of the local neighborhood association on that license. I do believe that we should be able to reach an agreement in short time.
Thank you. I'm sorry, Mr. Youssef, and I apologize. I did not write your name down, so I could call you by your proper name. So I do apologize, sir.
No problem.
Any preliminary matters that you want, not substantive, just any preliminary matters that you have that you wanted to bring to the attention? No?
No.
I think all right. As stated, it appears that the parties are moving towards settling this matter. If this matter is not settled, then it will be scheduled for a protest hearing on December 6, 2023 at 1:30 p.m. Now, if this matter goes to a protest hearing 7 days before the hearing, let me read these instructions, because I know this is a new license, and although the matter might be settled, but I need to make sure that the parties are aware that if it's not settled, then we go to a protest, that you are aware of the process. Now that we have scheduled this matter for a protest hearing, there are a few things that I would like to instruct the applicant and the protestants about, so that the protest hearing is focused and addresses only those issues that are being protested. The board does not intend to hear testimony or matters that are not relevant to the case. You should have received by electronic or regular mail a letter explaining the protest process, a copy of the protest information form, and a copy of the exhibit form. If you do not have these documents, please contact our legal office following this hearing. It is imperative that you review the rules closely and adhere to them before and during the protest hearing. You're also required to complete and submit the protest information form PIP and the exhibit form 7 days before the date of the hearing. These two forms and accompanying documents need to be submitted to ABCA's legal division and to all opposing parties in this matter. If we do not receive a copy of your PIP, your application, or your protest, whichever side you're representing, may be subject to dismissal. Likewise, if we do not receive a copy of the exhibit forms and the exhibit themselves, your exhibits may be excluded from the record upon a finding that the opposing party has been prejudiced or no good cause for the failure to submit has been shown. Likewise, witnesses other than a party may also be subject to exclusion if not identified on the PIP. Accordingly, these forms are very important. They greatly assist the board in narrowing the protest issues, facilitating the process, and keeping the parties on point during the hearing. They likewise provide notice to opposing parties, enabling them to better prepare for the hearing. As you're aware, all of our hearings are now being conducted virtually. You'll have 1 hour to present your case, and you'll only be allowed to call 5 witnesses. If you require more time to present your case and require more than 5 witnesses, please file a motion with the board, requesting additional time and additional witnesses. Any questions? All right. We thank you greatly for your cooperation. If you have any questions today or at any time leading up to the hearing, please do not hesitate to contact ABCA's legal division. So as I stated before, it appears that this matter will be settled. So if it's settled, I look forward to reviewing the settlement. The board will review the settlement and approve it. Good luck with your discussion. And if this matter is not settled, I will see you. If this matter is not settled, I will see you at the protest hearing on December 6th. Have a great day and good luck with your discussions.
Thank you.
Thank you.
All right. The next case in our calendar is case number 23 PRO 00078, Iraq Line, license number 116082 2. Good morning again, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Sure thing. Richard Bianco, your access has been elevated. Lyle Blanchard, your access has been elevated. DeJuan O'Donnell, your access has been elevated. Michael Shankle, your access has been elevated.
Can everyone please mute their lines, please? Please mute your lines until you're being asked to speak. Go ahead, sir.
And Ted Brownfield, your access has been elevated. That appears to be all, Chairman.
All right, thank you. Is there a Beckley Strauss? I don't know who that is. Sorry.
Yeah, Becky Strauss, your access has been elevated.
It appears that there are some other parties that needs to be elevated, Mr. Oriana.
I'm on now. I think it was me, ANC Commissioner.
All right, fine. All right, I'm going to ask, I know there are a lot of preliminary, there are some preliminary matters. Please, I don't know who raised their hands, but you need to be on camera, and then just let me state what I need to state, and you'll get an opportunity to speak. There are some preliminary matters in this case. What I'm going to do, I'm going to have all the parties identify themselves. However, it's my understanding that the group of 5 or more was dismissed from this case. So I'm not going to allow the group of 5 or more to speak until the board has made a determination whether or not. I know that they are so that's what I'm going to do. I'm just going to have everyone identify themselves, and then I will state moving forward how is it that we're going to proceed this morning. So, Mr. Bianco, can you please spell and state your name and let us know who you represent, sir?
Yes, Mr. Chair. Richard Bianco on behalf of the applicant Iraq Lion. My name is spelled RICHARD BIANCO. And to Mr. Grant, welcome.
Is your client here this morning, Mr. Bianco?
No, sir. They won't be
All right.
present this morning.
All right. Mr. Shankle, can you please spell and state your name for the record, please, and your representation?
Hi, my name is Michael Shankle. I am the ANC Commissioner from 2C 01. MICHAELSHANKLE. I'm the chair of the commission.
Good morning. Is there anyone else from the ANC here this morning?
Yes.
Who's that?
Rebecca Strauss, ANC
You're not-
TCO2.
You're not on camera, ma'am. So spell and state your name, ma'am.
Okay, I'm trying to turn on my camera. It is Rebecca Strauss, REBECCA STRAUSS.
Good morning, ma'am.
Morning.
All right, Mr. Blanchard, can you please spell and state your name for the record, and who is it that you would represent in this case, sir?
Good morning, Chairman Anderson and members of the board. My name is Lyle Blanchard. I'm representing the group of 5 or more. And I just wanted to say congratulations, Chairman Anderson, on your reappointment. And also Commissioner Grant, Board Member Grant, on your appointment. You were both confirmed by the City Council yesterday. I was watching the hearing, so I wanted to say that. And also, Mr. Short, thank you for your continued service on the board.
Thank you, Mr. Blanchard. All right, Ms. Farmer, can you identify yourself for the record, please?
Jessica Farmer of Holland and Knight, JESSICA FARMER, and I represent the protestant JP Morgan Chase Bank National Association.
Yeah, thank you. And who is Ted Brownfield. Identify yourself for the record, please. You're on mute, sir.
Ted Brownfield here, part of the group of five and designated as the spokesperson for the group.
Spell your name, sir, please.
TED and then Brownfield, BROWNFIELD.
Mr. Cohen, can you please identify yourself and spell and state your name?
Sure. Good morning, Mr. Chair. Christopher Cohen with Holland and Knight. That's CHRISTOPHERCOHEN. Also serving as counsel for JP Morgan Chase Bank National Association, protesting in this case.
Good morning.
Good morning.
I think we have Mr. O'Donnell. Can you identify yourself for the record? If you have a, I'm sorry, if you have a camera, are you able to turn your camera on? If not, spell and state your name and identify yourself for the record.
Sure, no problem. I think there's an issue with our company and certain applications like WebEx. I think we have Zoom, but not others. But in the interim, Dewan O'Donnell, D''J''UAN, O'Donnell, O''DONALD, and I representative of JP Morgan Chase Bank NA.
Good morning.
Good morning.
All right. Good morning. So as I stated before, Mr. Blanchard was a representative of the group of five or more. At roll call. That protest was dismissed. I know that it's been appealed and the board has not had an opportunity to review the documentation to make a determination. It's my understanding that the applicant is also, the group of five or more has filed a motion to be reinstated. The applicant has filed an opposition to reinstate the dismissed protest. It's also my understanding that the applicant has also filed a motion to dismiss the protest, the ANC from the protest, and the applicant has also filed a motion to dismiss JP Morgan from the protest. We are expecting the protestants' replies to the applicant's motion to are we expecting that the protestants' replies to the applicant's motion to dismiss? This is from JP Morgan and also from the ANC.
For JP Morgan, yes, we will be filing in opposition to that by tomorrow.
What about Mr. Shanko?
I'm sorry, I do not have. I have not received documentation that there has been a motion for the ANC to be dismissed.
Mr. Bianco, who did you file the motion? Who did you serve when the motion was filed, sir?
I believe I served all parties, but I'm pulling up the email right now, and I should be able to tell you in short.
And I also did not receive anything.
I'm sorry. This matter has been recorded. We have a court reporter, so if you're going to speak, I need you to either I recognize you or you need to identify yourself when you speak. Okay.
This is Rebecca Strauss, the other ANC commissioner. I never received any protest letter either.
All right. Thank you.
And Chairman Anderson,
Mr. Blanchard, yes, Mr. Blanchard. Yes, sir.
It's Lyle Blanchard. I don't know that I spelled my name earlier. It's LYLEBLANCHARD. And I just wanted to note that we will be filing a reply to the motion that Mr. Bianco filed this morning.
So, Mr. Chair, I think the question to me was, who did I serve? And I'm looking at my filing email to Abra Legal with the ANC motion to dismiss. And on that email CC'd is Michael Schenkel, ANC 2C01, Jessica Farmer, and Christopher Cohen.
And when was this email sent, Mr. Bianco?
Monday, October 30th, 2023 at 1:10 p.m.
Mr. Schenkel, is that is the email address that was read aloud by Mr. Bianco. Is that your official government email address, sir?
Yes, it is. I am looking for
And-
this. I just
Mr. Chair,
not find it.
just, I
Yes,
think to
Mr.
simplify
Bianco.
things, if the ANC needs more time to respond, as it seems we have filings that are to be going back and forth, I won't object.
Okay. All right, fine. So I'll ask what you also do, Mr. Bianco, since it appears that Mr. Shankly is having some difficulty locating your filing. Can you resubmit it to the ANC, sir? The original email that was sent to them with the date. And I think Miss Strauss, is this your single member district, ma'am?
It's in 2C. I believe it is. Michael, can you check on that?
I know that I always recognize the chair, but since you're here,
Sorry.
I was just getting some clarification, ma'am.
I'm sorry, Mr. Chairman. I missed your question.
No, I was asking Ms. Strauss if this was her single member district because she's also here. I know you're the chair of the ANC and she's also here. She had stated she did not receive a copy of the notice. So I was just trying to find out, was this her single member district, and direct that. I probably need to also ask Mr. Bianco to send her a copy since she said she didn't have a copy, but I'm providing you notice is probably sufficient notice, but
Michael can forward it to me.
I've
Okay.
just forwarded it to both Ms.
Thank you.
Commissioner Strauss and Schenkel.
All right, thank you, Mr. Bianco. All right, so currently the parties, I think somewhat. Oh, I guess Chase is the abutting is JP Morgan Chase as an abutting property owner. That's the purpose of. All right, okay, all right. So currently there are two protestants in this case until the board makes a determination whether or not we're going to reinstate the abutting property owner, and the board will also make a determination whether or not we will grant or deny the motions to dismiss the ANC and JP, the abutting property owner, from this matter. So that's basically where we are. But so the only parties then that I'm going to address directly are the ANC and the abutting property owner. Outside of the motions that were filed, are there any other preliminary matters that needs to be addressed?
No, Mr. Anderson.
Bianco.
No, Mr. Anderson. I can represent that we did engage in mediation. All the current parties were there and we were unable to resolve the matter, so it looks like we're moving forward.
Ms. Farmer?
The only preliminary issue is in the initial roll call and again at the mediation, I notified the parties that I have a trial that is scheduled from November 27th to December 13th. So I'm going to be requesting a continuance. I was waiting to hear back from the applicant about what dates would work for them, but I did want to just state for the record that I will be in trial on December 6th.
That is fine, because this is not, well, this is a transfer to a new location. I'm not quite sure if we have the same time constraints to issue a decision because this is not technically a new license. But if the parties file a joint motion, if this matter is going to a protest hearing, and if the parties file a joint motion, then of course the board will grant it if there's a joint motion. If it's a contested motion, then the board will make a determination whether or not we will grant it. And as stated before, this is a transfer, so I'm not sure if we're under the same time constraint as if this was a new license. But we probably are under time constraint because if we do not expeditiously go to a hearing, we would be preventing the party from operating. So, but we'll see. The parties can file the motions and then the board will make a determination. What is it that what the next step that will be taken? Are the parties familiar with, if this matter goes to a protest hearing, what the requirements are?
For the applicant, Richard Bianco, yes, we're familiar. We'll waive any formal reading of that.
Ms. Farmer, I see you're shaking your head.
Same for
Mrs. Shanko.
Yes.
The only difference that I will advise the parties is that if this matter goes to a protest hearing, because there's more than one protestant, the board is requesting that a party be identified as the representative of the protestant. As you are aware, you have 1 hour to present your case, and you're only allowed to have 5 witnesses. But if the parties determine that based on the complexity of this case, they need more time and they need more witnesses, then a formal motion should be filed to the board requesting that, they be allowed more time and more witnesses. All right, this hearing, if this matter goes to a protest hearing, is currently scheduled for December 6th at 1:30 p.m. But as you had stated, Ms. Farmer, you do have a conflict, so we will, if the board denies the motion, then I assume that the parties will file some type of motion to request that we continue this case for a period. And if this matter is not held December 6th, I believe that we're talking about January, February, March, based on what our schedule is currently, unless the board determines we're going to meet on a day which is not a Wednesday. Okay. All right. Any other matters before I bring closure to this case?
None from the applicant.
All right. The board looks forward to reviewing the motions, and we will make a determination, and we will see whether or not we'll have a hearing on December 6th at 1:30 p.m. Have a great day. Thank you very much.
Thank you.
Thank you.
Thank you. All right, the next case in our calendar is case number 23 PRO 00061, Rush, license number 125250. Mr. Oriana, can you please elevate the protestant in this case?
Sure. Zoe Cordelia Liu, your access has been elevated. That is all, Chairman.
Thank you.
Good morning.
All right, good morning. Mr. Bianco, can you identify yourself for the record?
Yes, Mr. Chair, Richard Bianco for the applicant, RICHARD BIANCO, and my client is not going to be appearing this morning.
Thank you, Mr. Bianco. Ms. Liu, can you please spell and state your name for the record and identify your representation?
Yes, good morning. My name is Zoe Liu, Z-O-E, and then last name Liu, L-U, and I'm the designated representative for the group of 9 protesting the Rush application.
Thank you. Mr. Bianco, are there any preliminary matters in this case?
They're not. We have a mediation on the books. We have not yet engaged in it. If there is anything to report following the mediation, we will certainly do so in writing to the board. If we have a resolution, the board can act on it in due course.
Thank you, sir. Ms. Liu, any preliminary matters you need to bring to the attention of the board?
No, not at this time.
All right. This matter is scheduled for a protest hearing on December 14th at 1:30 p.m. Are the parties familiar with the guidelines in having a protest hearing?
For the applicant, yes, we are. We'll waive any reading of the guideline.
Ms. Liu?
I would not mind a rereading of the guidelines.
All right. All right. Yes, ma'am. All right.
Thank you.
Now that we have scheduled this matter for a protest hearing, there are a few things that I would like to instruct the applicant and the protest about, so that the protest hearing is focused and addresses only those issues that are being protested. The board does not intend to hear testimony on matters that are not relevant to this case. You should have received by electronic or regular mail a letter explaining the protest process, a copy of the protest information form, and a copy of the exhibit form. If you do not have these forms, please contact our legal office following the hearing. It is imperative that you review the rules closely and adhere to them before and during the protest hearing. You are also required to complete and submit the protest information form PIP and the exhibit form 7 days before the date of the hearing. These two forms and accompanying documents need to be submitted to ABCA's legal division and to all opposing parties in this matter. If we do not receive a copy of your PIP, your application, or your protest, whichever side you're representing, may be subject to dismissal. Likewise, if we do not receive a copy of the exhibit form and the exhibit themselves, your exhibits may be excluded from the record upon a finding that the opposing party has been prejudiced or no good cause for the failure to submit has been shown. Likewise, witnesses other than a party may also be subject to exclusion if not identified on the PIP. Accordingly, these forms are very important. They greatly assist the board in narrowing the protest issues, facilitating the process, and keeping the parties on point during the hearing. They likewise provide notice to the opposing parties, enabling them to better prepare for the hearing. Also, as you're aware, all our hearings are now conducted virtually. You will have 1 hour to present your case, and you will only be allowed to have 5 witnesses. If you require more time, please file a motion with the board requesting additional time and or additional witnesses. Any questions?
No, thank you for that.
Okay. We thank you greatly for cooperation. If you have any questions today or at any time leading up to the hearing, please do not hesitate to contact ABCA's legal division. Good luck with your mediation. And if this matter is not settled, then we will see you at our hearing on December 14th at 1:30. Thank you very much. Have a great day. All right, the next case on our calendar is case number 23-251-00015, Shaw Howard Deli, license number 9195169. This case has been is being rescheduled to December 15th at 10:30 a.m. This is a second continuance requested by the parties, and the board will issue no further continuances in this case. The next case in our calendar, we have a fact-finding hearing for Aslan Beer Company. Mr. Oriana, can you please elevate the rights of the parties in this case?
Sure. Andrew Klein, your access has been elevated. David Rubenstein, your access has been elevated. Joyce Cowan, your access has been elevated. David Conklin, your access has been elevated. And Investigator Mark Ruiz, your access has been elevated. That is all, Chairman.
Thank you. I think Mr. Mixon is asking to be elevated.
His access has been elevated.
Thank you.
Sarah Edwards, your access has been elevated.
Good morning, everyone. This is a fact-finding hearing that was requested by the ANC. So let me have all the parties identify themselves for the record, starting with you, Mr. Klein.
Yes, good morning, Chairman Anderson, members of the board. Andrew Klein on behalf of the licensee. I echo the statements we heard earlier. Welcome you, Mr. Grant, to the board. Congratulations on your confirmation, and to you as well, Mr. Chair, on your reconfirmation. And as always, welcome back, Mr. Short. Thank you all. Happy to be here today.
Thank you, Mr. Klein. Good morning.
Good morning.
Mr. Mixon.
Hello, Cameron Mixon, also with the Veritas Law Firm, CAMERONMIXON.
Good morning, sir. Mr. Rubenstein. You're on mute, sir.
Thank you. My name is David Rubenstein, David Rubenstein. I represent ANC 2F01.
Good morning, sir. Ms. Edwards.
I am Sarah Edwards, and I am a neighbor directly behind Aslan.
Spell your name, ma'am.
Sorry, SARAHEDWARDS.
Good morning, ma'am. Mr. Conklin. Mr. Conklin.
Yes, hi, this is David Conklin, DAVIDCONKLIN. I apologize, I'm in a noisy location.
All right, good morning, Mr. Conklin. And I think we have one other party who will, I'm sorry, Miss Joyce, I did not catch your last name. Can you identify yourself for the record?
Joyce is unmuted, but not hearing audio.
I'm sorry. Yes, sir.
Mr. Chairman, is it possible that Mr. Conklin state which party he's with?
Mr. Conklin.
Yes.
Mr. Conklin, can you please identify your role in this matter, sir?
Yes, I live directly behind the Aslan Beer Garden, one house in.
All right, thank you, sir. Miss Joyce, are you there? Miss Cohen. It appears, well, Joyce Cohen is the other party, JOYCECOWY, and she's one of the neighbors, and it appears that she's having some technical difficulties, so she can join in when she can. And then we'll have Mr. Ruiz. Can you please spell and state your name for the record?
Yes. First name's Mark, M-A-R-K. Last name Ruiz, R-U-I-Z.
And what's your role, sir?
ABCA investigator.
Thank you.
Mr. Chair, Andrew Kelly, the principal of the licensee, is also here. We need his rights elevated.
All right. I don't see Mr. Kelly. Mr. Oriana, did you elevate the rights of Mr. Kelly? Give us 1 minute. Miss Cohen, I see. Can you please spell your name for the record? Miss Cohen.
Can you hear me?
Yes, ma'am.
Okay. Sound has been restored. For some reason, video is not, but it's Joyce, Joyce, Cowan, Cowan. And I will keep trying to figure out what's going on with my camera. But
And what's your relationship to this case, ma'am?
I am in the block of this establishment and involved in representing the ANC 2F is taking the lead, Mr. Rubenstein. But I've been involved in this case representing one of the designated members for the group of +5.
All right, thank you. And I think as soon as the licensee has been elevated, our IT
Has
person.
been elevated.
No, it's not Joyce. Mr. Klein, who is it that we should elevate, sir?
Andrew Kelly.
Andrew Kelly, Mr. Oriana.
There we go.
Thank you. Mr. Kelly, can you spell and state your name for the record, sir?
Andrew Kelly, ANDREWKELLUY.
Thank you. All right. This is a fact-finding hearing that was requested on the part of the ANC. So I'll ask you, Mr. Rubenstein, maybe you can inform us, why is it that the ANC requested a fact-finding hearing from the board?
Okay.
Hold on, Miss Cohen, I need you to mute your line, ma'am. Go ahead, Mr. Rubenstein.
So Aslan Beer Garden entered into a settlement agreement with the ANC and the Shaw DuPont Citizens Alliance and the neighbors back in, I believe, March 2022. Aslan is an outdoor beer garden with most of the frontage on a residential street, S Street, and a smaller frontage on 14th Street. The beer garden has an occupancy of up to 250 people. So obviously with a beer garden of that size and being outdoor, the neighbors were concerned with noise and trash, and the settlement agreement entered into in March 2022 dealt with those issues by calling for trash to be held inside until day of pickup, and requested that, which Aslan agreed to, is to undertake a sound study looking at ways to mitigate the noise impacts to the community. Throughout, because of the cycle, they were up for another renewal of the license in 2023. But once Aslan opened, we discovered that they were not holding trash inside, and that the sound study that the Aslan agreed to undertake was never undertaken. We attempted to call in enforcement on these settlement agreement issues, but that didn't seem enough. That didn't prove to be an effective way to get to the bottom of what was the issue in the settlement agreement. And at that point, as we moved through the next license renewal, which the ANC and the Group of Five and DuPont, Shaw DuPont Citizens Alliance were protesting, Aslan agreed to undertake the sound study that we originally wanted, and we gave up the clause in the settlement agreement which called for holding trash inside in exchange for 6-day-a-week trash service. So we dropped the protest, amended the settlement agreement, and moved on. And shortly after the timing was that shortly after the board approved the settlement agreement, Aslan would undertake the sound study, which they did. But we looked at the sound study and it did not meet the requirements of the settlement agreement, in our opinion. It only dealt with sound from amplified music through speakers. And the settlement agreement also called for consideration of options for absorptive and sound blocking materials and banners in the summer garden. It also looked to, look at what other establishments in the district had done in terms of sound mitigation. And there are several other issues which were in our breach notice to Aslan. So we sent them the breach notice, explained what we thought were the deficiencies in the sound study. Aslan sent a response back. And at that point, we were stalemated. And at the same time, we saw no evidence that Aslan had moved to 6-day-a-week trash pickup as they had agreed to. And so in consultation with counsel at ABCA, we decided the best way to resolve this probably would not be to call in inspectors, but to go directly to a fact-finding hearing, which is where we are today.
So, Mr. Rubenstein, what specifically in the settlement agreement are you saying that they're not complying with?
Okay. I've got 1, 2, 3, 4, 5, 7 bullet points. Shall I go ahead and read them to you?
Sure, sir.
Okay. These were in our breach notice to Aslan. So, number 1, the study that Aslan contracted for limits the recommendations to observe the restrictions of DC's noise regulations, Chapter 27 of Title 20. However, the settlement agreement noise mitigation provisions are broader than that, including requirements to recommend options to mitigate patron noise and options to bring meaningful and measurable reductions in noise. Number 2, there is no consideration of options for absorptive and sound blocking materials and barriers in the summer garden, which would mitigate noise from all sources, including patrons. Number 3, baseline measurements of noise only took place on a Friday night and did not consider Thursday and Saturday nights when baseline noise levels might be different. The settlement agreement speaks to all nights, all those 3 busy nights. Number 4, there was no documentation on management practices related to sound generation and therefore no consideration of options which might be available to reduce noise by modifying those practices. The settlement agreement calls specifically to look at management practices as well. Number 5, there was no consideration of measures adopted by other outdoor establishments in the district which would mitigate noise. We had drawn Aslan's attention to paragraph 8 and 10 from the settlement agreement for DACA, dated November 25th, 2015. For examples of options for sound absorptive materials and plantings which should be considered. 1, 2, 3, 4, 5. Number 6, the noise measurement location is limited to one location. It does not consider the impact on residents directly across the alley from Aslan. And the last item, the recommendations in the report should include turning off the amplified music when the establishment is closed.
So most of your concern is on the sound study, is that correct?
That is, those were the items in the that the sound study was to look at as per the settlement agreement.
But so I'm just to get some clarification. So, but those are there are no other aspects of the settlement agreement that you believe that they're not complying with.
So within 30 days of the board approval, they were undertake the sound study.
Right.
Which I just went through. Within 3 months of the board approval, they were supposed to actually start putting in place practices or start construction on the improvements necessary.
Okay.
In addition, they have not moved to 6-day-a-week trash pickup, which was agreed to in the settlement agreement.
Okay. Mr. Klein, what's your client's response to this, to where we are today, sir?
I mean, there are a number of facts that are just simply misstated. The fact of the matter is, Mr. Rubin, I'm sorry, Steen or Stein? I have it wrong. Stein, sorry. Mr. Rubenstein complains about purported violations under an old settlement agreement, which has now been amended and restated, so that's irrelevant. He points out that this property is adjacent to residences, but he neglects to mention that it's in the arts overlay zone. And the board has heard many, many times what that means in terms of from a zoning standpoint, that there needs to be a balance between the purposes of the arts overlay zone and the residences in the community. I mean, I regret that we ever entered into this agreement, and coincidentally, I received an email in connection with another case from the board's Assistant General Counsel, Mr. Berman, this morning, in which he says, and I think this is really appropriate here, quote, in negotiating agreements, the agency generally advises that parties focus on achieving specific results, e.g. no noise in residences, and not specific procedures and actions that may or may not have the desired effect, which can lead to disappointment and not resolve the real issues of concern between the parties. Now, that's very appropriate here in that we don't have any complaints of noise. We have complaints, well, they didn't do the study right. Now, I can go through, if the board desires, point by point and show how it is that what was required by the settlement agreement has been satisfied by the study. My client has spent over $12,000 on between the two studies, the first study was done contrary to what Mr. Rubenstein says. He saw the report. He knows it was done. So for him to represent that wasn't done is simply untrue. He spent over $12,000 in noise mitigation. I can go through point by point and show how it meets the requirements of the settlement agreement, if the board desires that I do that. With respect to the trash issue, I'm stunned to hear that about that for the first time today. And the ANC is the parties to the settlement agreement. As far as I know, I'm not aware that they've given any notice to cure. They are in breach of the settlement agreement by raising that issue today and not giving a notice to cure. Maybe one was given, but I'm certainly not aware of it. And I've been counsel throughout, and Mr. Rubenstein is aware of that. So if the board wants me to go through point by point, I'm happy to do that.
All right. Mr. Ruiz.
Yes, Mr. Chairman.
Are you familiar with this establishment, sir?
Yes, I am.
And are there any enforcement actions that you are aware regarding any settlement breach?
No, I was asked back in May of 2023 to conduct a review of the SA of the establishment, but I didn't find anything in violation.
You're saying in May of 2023, so
Yeah.
so you have not been. Are you aware if any ABCA investigator have visited this establishment since May?
I'm not particularly aware. I mean, I've driven by a couple times, but not particularly of anyone else that specifically has been to that establishment.
And a question for the licensee: does the licensee have any documentation in its possession that demonstrates that it has complied with the settlement agreement?
Yes, sir. We have the report. I mean, the issue here is the report, and Mr. Rubenstein complains that the report does not meet what was required by the settlement agreement. As I said, I'm happy to walk through how the report addresses that. So yes, we do have that. The acoustical engineer was hired. He's got a degree in acoustical engineering as well as substantial professional experience. So yes, we have certainly have documentation of that.
Then I would ask that, we're here for a fact-finding hearing, and why don't you tell us how is it that the licensee is in compliance?
Sure. We are dealing with Section 8 of the settlement agreement in case number 23-PRO 00008, approved by board order dated. Let's see when it's here we go, July 19th, 2023. I'm going to walk through the provisions of Section 8 point by point. Number one, the applicant will hire a sound engineer to ensure that the construction of the establishment incorporates noise mitigation. Well, Aslan did that twice.
Hold on, Mr. Klein. What settlement agreement that you're talking about? Because I remember you spoke earlier that the ANC was speaking about an old settlement agreement. So let us make sure that we are all dealing with the same document. So.
Yeah, that's why I gave the case number and the date, but okay. It's the amended and restated.
Mr. Klein, it's my first day back. All right, work with me, please, okay? All right.
It's the amended and restated settlement agreement, which bears the signature date of June 28th, 2023, in case number 23-PRO-00008. approved by board order dated July 19th, 2023. And that board order made 3 changes to the settlement agreement as submitted.
All right, sir, go ahead.
Okay. All right. So we're dealing with paragraph 8 of that settlement agreement.
I think you're frozen, Mr. Klein.
Sure that the construction of the establishment
Mr. Klein.
incorporates noise mitigation.
Mr. Klein, you're having some technical difficulties, sir.
Everybody went away. Can
You
hear
went
me?
away, Miss. We can hear you, Mr. Klein. You're the one who went away. We're all here.
Okay. All right. Everyone's video went away, so I wasn't sure. All right.
Okay.
Applicant had previously hired a sound engineer in connection with the initial protest that was referenced by Mr. Rubenstein. That was referenced in the initial, it was a requirement of the initial agreement. It was done before the initial agreement was even entered into in February of 2022. And then in connection with this order that I just recited, the amended and restated settlement agreement, a sound engineer was hired, performed measures and tests between August 4th and 5th of 2023, and resulted in a report that was not required to be provided to protestants pursuant to the board order, but as a courtesy, we did it because the applicant does want to work with these protestants. That's number one. Second point is section 8 says the applicant shall install and maintain sound absorptive and sound blocking materials and barriers, including but not limited to plexiglass on the property boundary fence in the summer garden. Now, this is a carryover from the prior agreement. The plexiglass has been installed. And in addition, the survey that was done in August recommended that Aslan relocate a couple of speakers such that they were under the canopy, and the canopy certainly acts as sound blocking material. Number 3, the applicant shall hire a qualified acoustical sound engineer to determine the measures, including sound absorptive and sound blocking materials and barriers, as well as management changes to operations and other measures adopted by outdoor establishments in the district. The tests that were done resulted in several recommendations, including the addition of sound absorptive blocking materials and barriers and management changes. One of the most important in terms of management changes was the purchase and installation of limiters to limit the noise from the amplified music, as well as repositioning the 2 speakers that I mentioned previously under the canopy. These certainly represent measures that are adopted by other establishments in the district. Limiters are pretty common. Mr. Rubenstein mentions specifically things that were done at another business, Dacha. That's no requirement of the settlement agreement. And certainly with the professional credentials of the acoustical engineer who was employed, who did the survey, presumably, we didn't pay him yet more money to be here today, but presumably he knows how to do this. This is what he does for a living. He has the credentials. And then it goes on to say, which would mitigate noise from amplified music, TV, speakers, and patrons. With respect to music, the survey recommended, again, that the 2 speakers be repositioned. The survey did not recognize TVs as a significant source of noise. And with respect to patron noise, the acoustical engineer cited the volume of noise from amplified sources, be it TVs or music or what have you. as a really important factor in managing the noise from patrons. As the board has heard, and as the board does, the louder the music is, the louder the TV is, causes patrons to then speak over or attempt to speak over the noise from amplified sources, which generally tends to raise the level of noise from patrons. And that was recognized in the report, and suggested that the management of the noise from amplified sources would deal with that issue. Then it goes on to say, with the goal of reducing current levels of noise experienced by residents generated on the busiest nights. Well, the measurements were done on Friday and Saturday night. Mr. Rubenstein apparently complains that Thursday wasn't included. But I think we all know that with a business of this type, Friday and Saturday are going to be the busiest nights. That was looked at. The report will be filed with ABCA as part of the application for license renewal. That will be done. What was struck was the requirement that we provide it to the protestants. We did that anyway, as a show of good faith. Just, here it is. If you in fact, I even wrote to Mr. Rubenstein, here it is. If you have anything to discuss, let me know. In terms of the work being done, that bears some comment. Mr. Kelly, who's on today, had a great deal of difficulty locating someone to do the study. Went through 3 or 4 different firms. In fact, we then wrote and said, we can't meet the 30-day requirement. We can't find anybody. We've started looking and no one can do it that quickly. We asked for more time. That was granted. So there's been compliance with that. That's been done. And then the section goes on, lastly, to state, after full implementation, the engineer will report on the effectiveness of the measures to confirm the measurable reduction from the current levels. And, we just haven't gotten there yet. I mean, the measures have been implemented, and that will certainly be done. There will be a follow-up to see that that's done. I mean, what we have here is, I guess, my fault in including on behalf of the applicant these requirements. And now we have the ANC and the other protestants not coming back and saying, oh my God, this is horrible, this place is noisy, but nitpicking and second guessing the report that the licensee paid over $6,000 for. And as I said before, the licensee has spent over $12,000 just in studies and over $30,000 in noise mitigation. And that would be, frankly, and I said it earlier, why we don't have the expert here today. Is my client is just like, I can't spend any more money. If there's an issue with respect to noise, tell us what it is. We haven't heard anything. What we heard was, we don't think the report did what it was supposed to do. But with respect to any actual issue, we haven't heard anything. And that goes back to Mr. Berman's quote that I read earlier, that maybe we didn't do a good job here. We should have just put some standards in and left to us to how to do it, because to have the community now come in and nitpick what an expert did, it just doesn't seem reasonable. And I should add that the order, Mr. Kelly tells me, containing the settlement agreement was provided to the acoustical engineer for his review. And his report was done to satisfy the requirements of that order, and we believe it does satisfy the requirements of the order. Thank you.
All right, thank you. Mr. Rubenstein, any response that you wish to make at this juncture?
Sure. I think, let me correct the record on a couple things that Mr. Klein said. First, on August 2nd, 2023, Aslan was notified of the lack of compliance with the 6-day-a-week trash pickup. So as per the settlement agreement, we sent the breach notice August 22nd, 2023. And
I'm sorry, Mr. Rubenstein, does the
yes,
settlement specifically direct where the notice should be sent to? And where did you
yes,
send this notice, sir?
yes. So Andrew Kelly, Andrew Klein, the other neighbors have all been copied on these.
Okay, go ahead, sir.
Then Mr. Klein said something odd because he said the study gave options for sound blocking materials. The sound study did not give options for sound blocking materials. I don't know if how we could be any clearer that sound blocking materials should be part of the construction of Aslan, which dates back to the establishment of the beer garden. It's on asphalt. It has a large brick wall on one side of it. It's a lot of hard surfaces. So never have there been any options given for sound blocking materials, despite what Mr. Klein said. Then Mr. Klein said that the measurements took place on a Saturday night. Yes, Saturday night, I believe after midnight when the beer garden is closed, not Saturday night when they're, open, 8 to midnight Saturday. Really, they were only tested on one night, Friday night. And then he said that the measures have been implemented. The sound study did suggest relocating 2 speakers. Those speakers have not been relocated as of today. So those are just a couple things I wanted to correct. So I don't know how we could be, ANC's neighbors, we enter into these settlement agreements. We're not the experts in it. That's why they have legal advice. That's why we have discussions with the ABCA staff, and it goes to the board for approval. If Aslan has agreed to do certain things, I know Mr. Kelly says maybe they shouldn't have agreed, included these in the settlement agreement, but the reality is the settlement agreement includes these. It envisions a sound study that looks at a wide number of options to mitigate sound and then calls for reasonable efforts to implement those results. If we're all going to enter into these as willing partners, which we did, then I think it's it's incumbent on the parties to do what they agreed to. Thank you.
Anyone else from your party wish to speak?
Ms. Cohen.
Ms. Cohen, please identify yourself. Go ahead, ma'am.
This is Joyce Cowan, C-O-W-A-N, and speaking as one of the neighbors and very involved in both rounds of negotiations with the settlement orders. I would second every single thing David said about nobody forced this applicant to sign the settlement agreement. It was heavily negotiated. He didn't want specific standards. We mapped out what we were expecting to happen in the scope of the review. That was ignored. And while the settlement agreement may have been handed to the engineer, I can't speak to that, but Mr. Klein says it was. The scope is very clear that they were looking at the DCRA requirements, not the overlapping but different ABCA requirements of noise impact on residents. So it is very clear in our opinion, which is why we wanted this to be a fact finding. It's not something an inspector can swing by and see what the sound requirements were in this study. So residents have been clear for a solid 2 years on the things we care about. There is no doubt in Mr. Kelly's mind what we care about. They did not perform the sound study after the first settlement agreement, which was what was
true. That's not true.
If you check,
I'm sorry. Hold on. I don't need the parties to be talking at each other.
Right. Can I finish?
The parties. You're right. That's what I'm saying. I'm trying to make sure that the parties should address the board.
This has been highlighted in email exchanges. This was prior to Mr. Klein being involved. A previous colleague was involved in this part. The date that the study that was done post the first settlement agreement was clearly done before the settlement agreement was signed. Mr. Klein forwarded that to us. He's just acknowledged it was done before the first settlement agreement. The settlement agreement, by the words on the page, was talking about a new one. Again, water under the bridge, but it's just a track record of this client signing things and then doing something else. They sign at the eve of a protest hearing and then decide after the fact, well, we weren't really going to do that. Same thing with the trash pickup. Same thing with if Mr. Klein wanted us to nitpick, we could go into all the other items that were not done in the first settlement agreement. But where we are today is two main issues: noise mitigation. This applicant did not want standards imposed on it, so we mapped out what the study should look at. We mapped out what the objectives of the study were: noise mitigation for a residential block, including, it didn't say if you feel like it, but including an evaluation of sound barriers, just to highlight that we were not expecting something extraordinary. We made a direct mention of the most relevant other beer garden, which doesn't even have as much frontage as this one does. Again, if the applicant did not want to agree to this, they should have struck it and we should have gone to a protest hearing. 6 days a week trash mitigation is 6 days a week. If the applicant's in compliance, they can provide a contract that shows they're in compliance. We have videotapes that shows it hasn't happened. Finally, in the smallest of things that their limited sound study did, reposition your speakers, as Mr. Rubenstein highlighted, didn't do it. This is after months. So I think it's very frustrating when we spend hours and hours and hours. We had counsel on the earlier part, and we invest a lot of time to work out a settlement agreement. And then we get to these stages and the applicant, who's just seemingly just resentful of having to deal with the neighbors at all, blows off a settlement agreement. And I'm on the alcohol and cannabis policy committee of the ANC now. And what do we say to all the other entities that sign settlement agreements and have a lot of expense and possible loss of revenue while they're compliant, if we let another applicant totally off the hook? It's a bad precedent. And I think it really undercuts the whole concept of settlement agreements in the district. Thanks.
You want to provide a response, Mr. Klein?
I do. Mr. Chair, the history of this location reflects that this community, despite the slot, as I mentioned earlier, being in the Arts Overlay District, does not want an outdoor business at this location. They fought the previous applicant, who never opened, tooth and nail. Then this establishment applied. They fought this establishment twice on the initial application and again on the renewal. And here we are today in a fact finding. And guess what? We have not heard a single word of from the protestants, which is anyone being disturbed by noise. What we have is nitpicking of a professional survey and report, but no one's saying, oh my God, this is as bad as we thought it was going to be. This is horrible. We have them coming in here and as I said, nitpicking what's an agreement when a professional had the agreement according to the applicant and did a survey based on what was required. And I have walked you through how it is, we believe in our minds, there's been compliance. And I think we come back to a misunderstanding as to what is an appropriate use at this location, given its zoning, which is in the arts overlay, and a desire that there not be an outdoor business here. It's been reflected since day one, and that's why we're here today, because this campaign will inevitably continue whether anybody's bothered or not.
Yes, Mr. Rubenstein.
Yeah, I'd like to just speak on behalf of the ANC, and the ANC is not opposed to outdoor businesses in our neighborhood. We all move here because Logan Circle is a special neighborhood and the adjoining businesses. But of course, an outdoor business requires balancing. And the balancing is represented by the settlement agreement. And balancing includes the number of patrons, how you handle trash, how you handle pest control, how you work to contain the noise impacts on the community. It's all spelled out in the settlement agreement. So I think it's very unfair for Mr. Klein to put a representation on the ANC that we are not in favor of our businesses and support all the outdoor activity, which we all love. So thank you.
You can lower your hand, Ms. Edwards. Go ahead.
Thank you. As a neighbor that is directly behind the beer garden, I just want to make it clear that, yes, I have in fact heard the music, heard the crowds, seen the trash, seen the rats, and I'd be more than happy every single instance to email Klein and Andrew that I'm aware of this. I have cameras, I can see it all, I have the recordings. So it is very much a thing, but instead of complaining every single time, which probably would be multiple times a day, I've decided to go through our group to make it more appropriate to do that. So I just want to put that out there. These things have been done. In fact, this morning I was listening to the music that was playing at the beer garden, which unfortunately woke me up.
I'm sorry. You said what was the hours of operation for the establishment? When you said this morning, are you talking about after midnight this morning?
No.
Or
during the normal hours. Just to be clear that I can in fact hear it from my house with no windows, doors open, and on the farther end of my house.
Aslan is open. Their hours are 6 to 11 on Sunday through Thursday and 6 to 12 on Friday and Saturdays, 6 a.m.
No, when you said morning, Miss Edwards, that's why I was you said it woke you up this morning. So I guess you're saying, what do you consider when you said this morning?
So this morning was probably about, I don't know, 8 o'clock, 8 in the morning, something like that, I would guess, 7 to 8 o'clock.
But they're not open.
Yes, they are. They have run a coffee bar in the morning.
Okay. All right. I apologize. But that's not, you said their hours are 6 a.m.?
Yes.
Yeah, 6 a.m. to 8.
Well, I don't know, Mr. Kelly can tell us exactly what his hours, but they're in the settlement agreement. It allows 6 a.m. to 11 p.m. on Sunday through Thursday, and Friday and Saturday, 6 a.m. to 12 a.m.
Okay, thank you.
And this was worked out in the settlement agreement and largely adhered to, so we have no issues with the operating hours.
All right, fine. Any questions by any board members? Go ahead, Mr. Short.
Thank you. For the record, can someone please tell us what was the name of the sound company, the mitigation company?
Yes, AKRF is the name of the company.
Is that the full name, Mr. Klein?
Yeah, as far as I can tell from their letterhead, AKRF, Environmental Planning and Engineering Consultants.
All right. Thank you very much.
Yep.
Go ahead, Mr. Grant.
Silas Grant here. Two questions. Do we have photographs of the speakers and them being repositioned before and after?
I don't at this point. I will submit the report which shows what the recommendation was with respect to the speakers and has a photo of where they were.
Okay. The second question is within the report, does it show the time that the report was started, the study was done, and the duration of the execution of the study?
Yes, and as I said, I'll submit the report so you can see for yourself.
Thank
I
you.
believe we have the report, Mr. Klein.
Okay, I thought you did, but
Yeah.
given the questions, I wasn't sure.
Yeah, well, at least I have the report in front of me. Does are the parties requesting an interpretation from the agency's legal division regarding the preferred interpretation of these provisions? Because it appears that there is some type of disagreement with the parties. Put your phone on. Yeah, there's some disagreement regarding the interpretation of the settlement agreement and what type of study, because I think from what I'm hearing from Mr. Rubenstein is that he believes that the study didn't appropriately comply with the settlement agreement. I hope I'm not incorrect. Yes, Mr. Rubenstein.
So we would say the study is very too narrow. So we're not saying what Mr. Klein undertook was not worthwhile, but it's very narrow, and that the settlement agreement envisioned a broader range of issues to be looked at. So that's item one. Item two is compliance with the 6-day-a-week trash pickup, which Mr. Klein could easily demonstrate by showing a contract that it's happening.
We'll go back and look at that. I mean, I looked at the email that you referenced, and there was another issue, which was the removal of a barrel, which you and I discussed many times. And even in rereading that email, I thought that was the focus of the email. And if I misinterpreted what you said, I didn't understand. I thought you were just reminding that trash pickup needed to be 6 days a week. I didn't realize that you were claiming that that wasn't being done. And Mr. Kelly apparently had the same impression. But we'll be right on that, and we'll be back to you on that.
I'm happy to send another breach notice to make that clear. If
You
that's
don't
necessary.
need to do that. We're gonna look into it and we'll let you know.
And then I just wanted to respond to that the speakers have not been moved yet. Is that correct? That's my understanding and my observation, and I don't know if the sound dampening or whatever it was called was implemented. I would have no way of knowing that.
Well, I guess the question I'm asking is are the parties able to, maybe they could negotiate the provisions? Because it appears that the parties are not in agreement what the provision of the settlement agreement states regarding the noise study. And is this something that the parties wish to renegotiate, or is it the parties are asking for the board to provide our legal interpretation of what it is that's required by the study as per the settlement agreement?
The ANC feels that it's been very clear in the settlement agreement about what the sound study should encompass. And so we're asking the board to enforce that provision of the settlement agreement. Paragraph 8.
All right. So if the parties believe, or if the ANC believes that the licensee is not in compliance with the settlement agreement, of course they can file an action with enforcement to say that because that's one of the reasons why I'm somewhat unclear. It appears that there's some disagreement over the terms itself. you're saying that the licensee has not complied because the sound study was not comprehensive enough. And Mr. Klein is saying that he disagrees. You're just nitpicking, and that's why I'm just trying to get some clarification with that.
So I was informed by speaking to ABCA staff, Ms. Stark in particular, that the fact finding would be the best, given that we've already been through one round of inspections on this matter and it was not able to bring it to any resolution, the recommendation that this would be a more effective way to resolve the issue about the sound study.
Now, let me ask you said inspection. Inspection in what sense? Provide some clarification.
It's a little water over the bridge at this point, but I'm happy to go back to it if you'd like.
No, you said that you've been through inspection and that hasn't.
Okay. So
I'm just asking for clarification.
Although what happened in the past is not really an issue for today, the first settlement agreement envisioned a sound study that would provide options for sound mitigation and barriers to be part of the construction of the establishment. The establishment had not yet been constructed. So the settlement agreement envisioned a sound study looking at these issues and what could be incorporated. So as the sound study that Mr. Klein refers to was a sound analysis of how loud the establishment would be. It was not a sound study that gave options for construction. So this was never done as required in the first settlement agreement. And so we made a complaint to ABCA, provided them with the sound study that was not compliant, and said, here, look, it's not in agreement with the sound study, with the settlement agreement. So despite multiple tries, I couldn't, the inspectors were looking at what was the noise impact of the establishment now that it was opening. It was not looking at, as far as I understand, the inspecting team did not look at whether the sound study had been properly done or done at all.
And so that's one of the reasons why.
That's the issue on the table with the new settlement agreement. The recommendation in discussion with ABCA staff was this would be the right forum to resolve
Mr.
that.
Chair, I think we could get to legal. In terms of the first sound study, I mean, my client acted in good faith, and he has been penalized because he did the sound study while they were negotiating, and he went ahead and did it. And then they entered into an agreement, and the agreement recites that a sound study will be done, and it was already done. And it's kind of like, well, don't do that again. I mean, don't be proactive, because apparently if you don't do it until after the agreement is signed, you're going to have a problem with complaining, oh, we meant a different sound study, not the one that you already paid $6,000 for. So let's put that to bed. In terms of where we are now, what I think is that my office should be given a brief period of time to respond in writing to the September 29th letter from Mr. Rubenstein, rebutting, as I did orally today, the points that are made that there's a violation in terms of what was done, and then have legal make a determination. And if legal says that no, they didn't comply, then I guess my client will spend some more money and we'll bring the engineer back out.
All right. Hold
on. Question?
Yeah, hold on 1 minute, please. Yes, sir. Go ahead. What was the question?
So just in terms of process, if it's a legal review, we provided the breach notice on this issue to Mr. Klein and Mr. Kelly.
Okay.
They're going to provide a response. Are we able to provide a response to that response?
Well, then they're going to provide a response to the response. I mean, there has to be reason, there has to be some reason. Mr. Klein stated that he's going to provide a response to your letter of I think August 29th.
He already did. He responded to us already.
All right.
Yeah.
So
what
letter to us, not the letter from Mr. Rubenstein to us, we responded to, but then there was a letter to the board, which resulted in this fact-finding hearing.
Yes,
and that's what we're suggesting that we would respond to.
That's right.
All right. So you, Mr. Klein, will respond to the ANC's letters to the board, and it appears that there's some misunderstanding. The parties, it's not apparent that the parties are in the same wavelength in the sense of what it is that's required, what a settlement requires regarding this sound study. So what I'm suggesting, and maybe if the parties are asking, is for legal to provide our interpretation of what it is that's required based on the settlement agreement. So, as you stated, Mr. Klein, the study could have been done prior to the settlement agreement, but if the study complies with what's required in the settlement agreement, whether or not it was done before, during, or after, it's irrelevant, because if the settlement agreement regarding a sound study and the settlement agreement states this is what needs to be a part of the study, we can look at the study and legal can state whether or not the agreement, the study complies with the agreement.
Yeah, I mean, if I could just clarify the record, because it seems we're a little bit confused. That issue actually related to the first agreement. We're now under the amended and restated agreement that was approved by the board in July, and the subsequent study was done, and that's what we're talking about now is the subsequent study. The fight over whether it was done before or after the settlement agreement related to the first settlement agreement. We're now talking about the amended and restated. I don't think there's any dispute that the study was done after the amended and restated was entered into, but the protestants have issues with the scope of the study, as I understand it from the letter and from the discussion today, and as to whether it complied with the requirements of Section 8 of the amended and restated settlement agreement.
And so therefore, legal will look at that issue.
After we provide a response.
Yes, and provide clarification to the parties if we believe that this study is in compliance with the settlement agreement.
Yeah.
Mr. Rubenstein, you have a question you're asking.
No, I'm just going to say for the first time today, I'm going to say I agree with Mr. Klein in his summation of the issue.
Mr. Rubenstein, I hope that you and Mr. Klein, because you're the ANC, Mr. Klein represents the licensee, and the licensee is in the neighborhood, that you will always agree. That's what I want, because you're going to coexist, so you have to agree.
I will say for the record, despite that this may have appeared contentious, Mr. Rubenstein and I actually get along very well and work well together. So just for the record, I'll put that out there. That's my opinion, at least.
And I'll state that I remember, well, I've been on this board long enough that I do remember the protests that was filed by the community regarding the original licensee, because we were here and we were doing in-person hearings at that time. And we were here till 2 a.m. in the morning, listening to the community. So that was, at that juncture, that was the longest protest hearing that I'd ever had, because we were here till 2 a.m. in the morning for that protest. And so I was glad that once this other license came about, the other parties were able to sign a settlement agreement to come to some type of agreement. So the board supports, as I've always stated, we support settlement agreements because at least it says that the community and the licensee, they're both working together to come to a mutual agreement. And so I do support that.
I caution against scaring off Mr. Grant his very first day on the board.
Well, Mr. Grant is fortunate today because on our calendar today, Mr. Klein, there was a protest hearing, and I'm not sure if Mr. Grant would have been happy to have a protest hearing his first day, a day after he was confirmed by the council. But apparently the parties, and I'll say it this way, that they are so afraid of Mr. Grant that they quickly decide to sign a settlement agreement because they did not want to face the wrath of Mr. Grant. All right.
Yes,
So,
we do.
yes. All right. So I want to thank the parties for settling that matter. All right.
Chairperson.
Yes, Mr. Grant.
I did have a question. I wanted to go back.
Yes, sir. Go ahead.
Several minutes ago, when Sarah Edwards talked about the 8 a.m. music. When that happens, Sarah, what is your typical response or your line of communication to notify someone if that's taking place?
Let me ask you before. Let me ask. Let me get some clarification, Mr. Grant, because before that question is answered, because Mr. Klein, and what's the hours of operation? Because I'm looking at I am looking at the placarded notice, and this was from October 7th, 2022, and I thought that the hours of operation are from 11 till 11. So where did this 8 a.m. come about? Because and that would be responsive to your question, Mr.
Yeah,
Mr.
I don't know,
Mr.
Mr.
Grant.
Chair. I'd have to look into that. It's the first time
All right.
hearing about this issue.
All right, but you can, if you're Miss, go ahead. Go ahead.
The reason for asking that is because Mr. Klein has stated that a couple of times here, there's been no complaints about actual noise. There's been complaints about the way in which the study was executed. But now we're hearing that there was at least an informal complaint about the music happening this morning. So under normal circumstances, how would a neighbor notify that there was noise at an inappropriate time?
Go ahead, ma'am.
Yeah, so currently it's just one of those everyday things. I'll hear a crowd roar, or I'll hear the music turned up, or the garbage, clinking in bottles, or, that kind of thing. So right now there's no formal process that I've been putting through for complaints. It's just our group of neighbors. We know it's an everyday thing. If you would like a formal complaint every single time I hear something, I can certainly do that. The problem is somebody comes out and it's 3, 4, 5 days later, or a few hours later, and it's completely quiet, or it's the middle of the night, or there is no more, noise or trash issues at that time. So like I said, I'm happy to text or email every single time I hear a noise or a trash violation or a concern of mine. But you're going to get a lot of messages, unfortunately. So it's kind of up to you.
Ms. Cohen.
Yes, and I think, especially to the new member of the commission, I think this highlights, Sarah's example highlights why we're not in the land of nitpicking. We have an operation on our block that is open from very early in the morning, although not serving liquor until later in the day, with music that you can hear inside a house with doors and windows locked. As Mr. Klein well knows, the difference between the DCRA noise mitigation, which the sound engineer focused on, that is a different decibel level issue. The ABCA's laws and regs go to a broader point, which is what can residents hear inside. And that's why we had a fundamental problem with the sound study that was conducted. It did not look at that. It did not ask for permission to go inside anybody's house and listen to see if we're a bunch of paranoid weirdos or if in fact you can feel the vibrations and hear the noise. In fact, the sound engineer, as David nicely was highlighting, and we can give legal counsel, I think that's a great idea, a little chart. It looks like they checked noise at a whole bunch of different times, but they measured it like I think 5 different times after the operation was closed. How on earth would that get to a proper noise mitigation standard when you're checking noise after patrons have been gone for an hour? I guess staff likes to listen to music when they're closing up, whatever. But the difference between DCRA decibel levels, which are very high threshold, we get it. We live in this neighborhood. And ABCA's focus on should residents be able to hear an establishment inside their house night after night. Yes, we're happy to make boatloads of complaints, but until inspectors can come out at, I get it, they have to prioritize their time, and serving underage people and other things is certainly higher priority. But until we can have inspectors that can actually see what's going on in somebody's house at the time it's going on, that's why we felt we were told a fact-finding approach was the way to go on this.
Yes, Mr. Short.
Thank you. I have a suggestion to Mr. Klein and to the community. And Mr. Klein, you might remember, I think we've done this before. I'm gonna make a suggestion that the noise company or engineers come out at a time when the harbor investigator is available and the community is available and the business owner is available, and that the sound engineer goes to the units and have an investigator go to the units while the test is being done. And that way, that would answer, I think, a lot of the questions that seem to be not being addressed appropriately, I would say. But at any rate, I will make that suggestion, Mr. Chair, that the sound engineering company, along with our harbor investigators and the community and the business owner, arrange a date when the sound engineer can come out and check inside the residences.
All right. The board is also reminded that if they can revisit that provision, the provision of the settlement agreement where it appears that there is not agreement on the interpretation. All right, so that's also available to them. I am confused about the hours of operation for this establishment because I'm not aware that this establishment is supposed to be open at 6 a.m. in the morning. And even if alcohol is not being sold, your license should reflect your hours of operation. So if your hours of operation is from 6 a.m. in the morning until 11 p.m. or 12, that should be reflected on your license, and then your licenses will also reflect the hours of sale and service. So Mr. Klein, if there is some confusion there, I'm asking that you look at the license to make sure that your client is in compliance with its obligations under its license.
Yes, we'll look at that, Mr. Chair.
And if that's the case, then and I don't know what it is, but if that's the case, then your client needs to file for a substantial change to change its hours of operation.
Well, I'll a request for a change. We'll leave the rest of it to you in terms of whether
Well, the board can determine whether it is substantial or not. But as you know, I'm advising the party, and so I'm also, since we are fact finding here, and also advising the parties that if the hours of operation is not in compliance with the license, please cease operation as of today. All right. So what is the next step is that Mr. Klein, you're going to respond to the protestant's letter to us, and the protestant will be given an opportunity to respond to your response, and that's it. And then legal will make a determination, the next steps on the interpretation. If the parties believe in the interim that they want to negotiate and make changes, that they'll be on the same wavelength. Of course, the parties are always available to negotiate and come to the board to say this is our we're going to amend our settlement agreement, and this is this interpretation that we both are in agreement with. Yes, Mr. Rubenstein.
I just want to make point out to Mr. Klein, there were 2 letters to the board, one on trash and one on the sound study, just so you have both.
Okay, I don't believe I've seen the one on trash, but I'll look at it, and if I don't have it, I'll be in touch to get it from you.
Or ABCA Legal has it as well, so they were sent both.
And I thought I'd seen a trash contract, and so therefore there should be clarification from the parties. Clearly, if the settlement agreement says the trash needs to be taken up 6 days a week, then that's what the settlement agreement states. So there should be some contract that the parties can discuss whether or not is there 6 days a week trash pickup as per the settlement agreement, if that's what the settlement agreement states. Any other questions by any parties before I bring this matter to this hearing to closure?
None from the licensee.
Mr. Rubenstein?
None from the ANC.
All right, thank you very much. Thank the parties for their participation today. Of course, the board will take this matter under advisement and will issue a decision in due course. Thank you very much. Have a great day.
Thank you.
Thank you.
All right. We're at the end of our morning calendar, so let me call our afternoon calendar. Our afternoon calendar is case number 22 PRO 00112 / license number 90823. This case has been canceled due to the submission of a settlement agreement to the board for its review and approval. And so therefore we're at the end of our agenda item for the day. We're going to address our calendar item for the day, but the board is going to take a 10-minute break for us to come back and address our calendar. So our agenda item. So we're on. So we're just going to take a 10-minute break. We'll be back in 10 minutes. It's 12:32. We will come back on the record at 12:40. So 8 minutes. 12:40. Thanks. We're back on the record. We will now do our legal agenda. The first matter on our legal agenda is a review of a settlement agreement dated October 24th, 2023, by and between Advisory Neighborhood Commission 5F and Dance Place, license number 125838. I make a motion that we approve this agreement. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0-0. The second matter on our legal agenda is a review of a request to reinstate dismiss application dated October 26, 2023 in case number 2023 PRO 00077. This is Minya's Pizza, license number 125665. This morning at our protest hearing status, the board voted 3-0 to reinstate the dismiss application. The next case is number 3, review of consent motion to continue show cause hearing dated November 7th, 2023 in case number 23251-00015 Shaw Howard Deli, license number 095169. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0-0. Number 4, review of government's motion to continue show cause hearing dated November 7th, 2023 in case number 23CC 00009 Heights Liquor, license number 118369. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0-0. Number 5, review of applicant's motion to dismiss protest dated October 23rd, 2023 in case number 19PRO 00033 El Canale, license number 083707. I make a motion that we grant the motion in part and deny in part. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0-0. Number 6, review of protestants' motion to suspend protest dated October 24th, 2023 in case number 19PRO 00033 El Canale, license number 083707. I make a motion that we deny this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0-0. Number 7, review of applicant's opposition to protestant motion to suspend protest dated October 25th, 2023 in case number 19PRO 00033 El Canale, license number 083707. This matter is now moot. Number 8, review of protestants' reply to applicant's opposition to protestants' motion to suspend protest dated October 25th, 2023 in case number 19PRO 00033 El Canale. This is also moot. Number 9, review of Advisory Neighborhood Commission 2E's correspondence to the ABCA board regarding certain New Year's Eve privileges for Tony and Joe's and Nick's Riverside Grill. This is an FYI to the board. Number 10, review of the position of the 9th Street Nightlife Equity Coalition dated November 3rd, 2023, regarding the petition for the establishment of a moratorium zone in the 1900 block of 9th Street Northwest. This is an FYI for the board. Number 11, review of the Westminster Neighborhood Association's opposition to the 9th Street Neighborhood Equity Coalition's motion for reconsideration, rehearing, and in the alternative to dismiss the petition dated November 2nd, 2023. This is an FYI for the board. Number 12, review of the second supplemental information dated November 3rd, 2023, filed by the Westminster Neighborhood Association in support of the petition for the establishment of the moratorium zone in the 1900 block of 9th Street Northwest. This is also an FYI for the board. We now move to our licensing agenda. The first matter on our licensing agenda is review application for safekeeping of license. This is for Cookie Corner, license number 111680. I make a motion that we approve this request through March 31st, 2024. Is there a second?
Mr. Grant, second the motion.
Mr. Grant, a second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 2, review request for an off-premises storage permit to store unopened alcoholic beverage inventory off-site in the lower level space at 1020 19th Street Northwest. This is for One West DuPont Circle Wine and Liquors, license number 074429. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 3, review request for approval to provide a gift of a frozen drink machine that does not exceed $500 in value to various licensed retail establishments. The request has been made by Breakthrough Beverage, license number 124554. I make a motion that we approve this request. Is there a second?
Mr. Grant, second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. I'm now taking up the supplemental licensing agenda for November 8th, 2023. On the supplemental licensing agenda, there are 2 license requests. I move that the 2 license requests on the supplemental licensing agenda for November 8, 2023 be approved. Do I have a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now take a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. I'm now taking up the notice of vacated cease and desist agenda orders for November 8th, 2023. On this agenda, there are 15 items. I move that all 15 items be approved to vacate the cease and desist for the licensees on this agenda for November 8th. Do I have a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. I'm now taking up the cancellation agenda for Wednesday, November 9th, 2023. On the cancellation agenda, there are 6 items on this agenda. I move that all 6 items be to cancel the license be approved. Do I have a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passes 3-0. We now move to the medical cannabis licensing agenda. The first matter on our medical cannabis licensing agenda is the review of a standard application for conditional cultivation center license. This is for Sophistries, SOPHISTES LLC, license number 126418. I make a motion that we approve this request. Is there a second?
I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 2, review of standard application for conditional manufacturer's license. This is for Sophistries LLC, license number 126679. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 3, review of standard application for conditional cultivation center license. This is for DC Bloom LLC, license number 126497. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 4, review of standard application for conditional manufacturer license. This is for DC Bloom LLC, license number 126495. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. I'm sorry, 3-0. Number 5, review of standard application for conditional courier license. This is for DC Courier LLC, license number 126488. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 6, review of social equity application for conditional manufacturer's license. This is for Bud Appetit Edibles, license number 126293. I make a motion that we approve this request. Is there a second?
Mr. Short. No. Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 7, review of social equity application for conditional cultivation center license. This is for Farm 51, license number 126297. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 8, review of social equity application for conditional cultivation center license for Tupez TURPZ LLC, license number 126783. I make a motion that we approve this application. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 9, review of social equity application for conditional manufacturer license. This is for Turpez TURPZ LLC, license number 126783. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 10, review of social equity application for conditional manufacturer license. This is for 87 Walnut, license number 126664. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 11, review of social equity application for conditional cultivation center license 487 Walnut, license number 126639. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant,
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 12, review of social equity application for conditional manufacturer license. This is for New Leaf Genetics, Inc., license number 126687. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 13, review of social equity application for conditional cultivation center license. This is for District Canopy, CANNACOPIA LLC, license number 126589. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 14, review of social equity application for conditional cultivation center license. This is for Fremont Holding DC LLC, license number 126729. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant,
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 15, review of standard application for conditional manufacturer license. This is for Reds Health and Wellness LLC, license number 126757. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant,
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 16, review of social equity application for conditional manufacturer license for the Reset Wellness, license number 126746. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 17, review of standard application for conditional manufacturer's license. This is for Funky Piece Company CO, license number 126748. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 18, review of standard application for conditional cultivation center license for Funky Piece Company, license number 126749. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 19, review of standard application for conditional cultivation center license. This is for JAWI Cultivation, license number 126793. I make a motion that we approve this request. Is there a second?
Mr. Grant,
I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 20, review of standard application for conditional manufacturer license. This is for JAWI Cultivation, license number 126796. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant,
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 21, review of social equity application for conditional manufacturer license. This is for Gas Monkey LLC / Munco, license number 1266 744. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant is second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 22, review of social equity application for conditional cultivation center license. This is for Gas Monkey LLC / Munco, license number 126550. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant,
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 23, review of standard application for conditional manufacturer license. This is for Alpha Processor, license number 126728. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 24, review of social equity application for conditional manufacturer license. This is for Dukes and Duchess Enterprises, Inc., license number 125617. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant,
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 25, review of social equity application for conditional manufacturer license. This is for Dukes and Duchess Enterprises, Inc., license number 126816. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant,
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 26, review of standard application for conditional manufacturer license. This is for Green Label Consulting LLC, license number 126763. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 27, review of social equity application for conditional cultivation center license. This is for HLS LLC, license number 125502. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 28, review of standard application for conditional cultivation center license. This is for BioLeaf Holdings LLC, license number 126758. I make a motion that we approve this request. Is there a second?
Mr. Short, I agree.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 29, review of standard application for conditional cultivation center license. This is for 24-Hour Consulting LLC, license number 126761. I make a motion that we approve this request. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passes 3-0. Number 30, review of social equity application for cultivation center license. This is for Powerhouse Cultivation Center, license number 126737. I make a motion that we placard this matter. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 31, review of social equity application for manufacturer license type 1. This is for Powerhouse Cultivation Center, license number 126410. I make a motion that we placard this matter. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 32, review of social equity application for new licensed retailer license with delivery endorsement. This is for No Kids Allowed, license number 126724. I make a motion that we placard this matter. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 33, review of social equity application for new retailer license with delivery education, tasting, safe use treatment facility, and summer garden endorsement. This is for New Leaf Smoke Shop LLC. I make a license number 126727. I make a motion that we placard this matter. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
Mr. Anderson, I agree. The matter passed 3-0. Number 34, review of standard application for new retailer license with delivery endorsement. This is for Granny's The ZA''S, license number 126762. I make a motion that we placard this matter. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. Number 35, review of standard application for new retailer license with delivery endorsement. This is for Calvias, Kaliva, license number 126777. I make a motion that we placard this matter. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passed 3-0. I'm now taking up the board's temporary license and one-day substantial change docket for November 8th, 2023. On this docket, there are 10 licensees. I move that the items on the agenda be approved. Do I have a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passes 3-0. I'm now taking up the license administrative docket for Wednesday, November 8th, 2023. On this docket, there are 13 applicants. I move that the 13 items on the license administrative docket for today be approved. Do I have a second?
Mr. Grant, I second the motion.
Mr. Grant, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. The matter passes 3-0. We are now at the agenda item, the end of our agenda items for the day. We previously concluded our calendar for the day. So if there's no further board business, I now move to adjourn for the day. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with Title III, Chapter 405, Office of Open Government, I move that the ABC Board hold a closed meeting on November 15th, 2023, for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for November 15th, as published in DC Register on November 9th, 2023. Is there a second?
Mr. Grant, I second that motion.
Mr. Grant has seconded the motion. I will now take a roll call vote on the motion before us now that it's been properly seconded. Mr. Short.
Mr. Short, I agree.
Mr. Grant.
Mr. Grant, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed 3-0-0, I hereby give notice that the ABC Board will hold this closed meeting pursuant to the Open Meetings Act. Notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar on ABCA's website, and published in the DC Register in as timely a manner as practically. We are now adjourned for the day. I would like to thank the members of the public who have participated in our hearings today. And I would also formally once again welcome Mr. Grant to his tenure on the board. Thank you, sir, for being here today. And thank you. And thank you, Mr. Short, for your continued service to the board. We're now adjourned for the day. Have a great day. Thank you. And I now direct all board members to return to executive session for further action. Have a great day. Thank you.
Yeah.